Ripple pulls off another smart move. Let's get into it. So Chris, some fantastic news with Ripple pulling off yet another smart move in its case against the SEC. They seem to be on a roll right now, right? So yeah, interesting stuff, right?
Definitely, Nick. I love a sitcom. Should we get straight into it?
Of course, but before we do, just a gentle reminder, if you do find this useful, informative, maybe even a dash entertaining, hit the like button. We both really do appreciate that. And of course, if you're new to the channel and you're not yet subscribed, do go ahead and subscribe, because by subscribing, you're going to be kept up to date with all of the videos and live streams that we do here at Cheeky Crypto. It's free, you'll be kept informed, so yeah, why not? Right, Chris, with that said, let's jump to the desktop and see exactly what Ripple have done here.
Yeah, let's do it, Nick.
Absolutely. So Ripple pulls off another smart move in its case against the SEC. So in the legal battle between the US Securities and Exchange Commission, SEC, and Ripple, both parties continue to provide an uninterrupted exchange of blows. And I can just imagine them both in a boxing ring. No, actually, no, scrap that, Chris. Let's get them in a cage. Think. Cage is better. It's better. A cage is always better. Throw in a few additional objects of random objects. That'll help. That'll help the blows. But let's carry on, right? So in a letter sent yesterday to Magistrate Judge Sarah, Ripple's lawyers write that the SEC's refusal to release its documents on the classification of Bitcoin and Ethereum are based on misrepresenting the representation of the facts and a self-serving, prediction in the case's outcome. And that's incredibly interesting. So we want to see how that thing evolves over time, because we did a video on this yesterday, in fact. And ultimately, it was all about how Ethereum sales actually represent more of a security sale than that of XRP. And yet, no action was taken against, 𝗕𝗘𝗪𝗔𝗥𝗘. So really interesting kind of concept, because if the SEC are refusing to release those documents on how they would categorize them as, non-securities, yet XRP they're trying to categorize as a security, makes you wonder what's inside those documents. And the fact that they're refusing just makes it even more speculative. So was it in fact, a self-serving prediction of the case's outcome? Let us know what you think in the comments down below. Really interested to know what you guys think about the refusal to release those documents. So, Chris, let's carry on a little bit further. The Ripple lawyers give reasons why the documents on Bitcoin and Ethereum, as well as the SEC's internal documents on Bitcoin, Ethereum, and XRP are relevant. According to the letter, Ripple attorneys are looking for evidence that the agency contributed to widespread market confusion regarding XRP. And here's the quote, right? So defendants instead seek documents that reflect, either directly or using internal communications as a proxy, how XRP was viewed in the marketplace. The SEC cannot deny that the agency is a focal point for requests for regulatory guidance as to whether XRP it was a security. So really interesting. Again, this, if you think back a little way ago, around how exchanges supposedly approached the SEC around the status of XRP and whether or not they were allowed to sell it on their exchange. And obviously they got the green light because it was listed. So what's really interesting here is if the SEC had internal communications about the status of XRP, and yet still were allowing exchanges to list it and sell it to retail investors, what actually is going on? It's all it's a bit of a mess, really, Chris, because it's very confusing.
Yeah, it just seems like something's being hidden, and I don't necessarily believe that it's because of XRP or communications around Ripple. I think there's something else, and particularly around Ethereum and Bitcoin. Look, I'm not suggesting that the SEC is corrupt in any way. But
I mean, when Chris? I mean, come on. When have governments been corrupt? They're just not their idea.
No, but with that said, you've got to look at some of the headlines that you can find and the admission of guilt from banks and other institutions, right? In this space, in other investment spaces, metal markets, bond markets, you name it, that there's been an admission of guilt from various different, you know, entities, right? So do I consider the SEC, you know, an institution that could be involved in that sort of stuff? Potentially, right? Like, you know, I'm surmising, don't get me wrong, but you know, it all seems a little bit unusual. The timing's off, you know, the fact that, you know, they've had to, you know, amend their complaint, the fact that, you know, they've had to make other changes as well. I just kind of feel like it doesn't all add up, you know, if it was for the right reasons. And you know, I still believe, you know, hand on heart, that there would have been a better approach that could have been done if your goal as you know, a governing body, I guess, is the way that I would describe it, is to look after and sort of have the safety of retail investors at heart, and that's your primary goal. Then I do have to look at the damage that's been caused to retail investors and question why they took this approach. And yeah, for me, it all just seems off.
It does, it really does. But let's continue and see what else, what other nuggets are in this article, right? So both attorney Jesse Haynes and attorney Jeremy Hogan celebrated the letter as a great one from Ripple. While Haynes wrote via Twitter, "This response is fire, in my personal, not legal opinion." Hogan stated that after this letter, the judge will have no choice but to grant Ripple's motion and be, you know, supportive of disclosing the documents. And here's the quote for that: "I would be shocked if judge does not make the SEC provide these documents." And further, Hogan also analysed that the lawsuit against Brad Garlinghouse and Chris Larsen could, you know, brings knowledge of the wrongdoing into play, and that is turning into a big mistake for the SEC, as it is what makes these documents relevant. How big a mistake will depend on what is in the documents. Ripple's lawyers may have already found a first mistake in the process. Hogan tweeted the following: "Another very big interesting thing hidden in a footnote. The SEC told a retail XRP holder that emailed the SEC that it had not made a determination as to whether XRP was a security in, wait for it, in October of 2020. They might have been drafting the lawsuit in October." Interesting stuff. I mean, could you imagine? I mean, there's just one thing after another with the SEC. I think they really need to go back to school.
I think they are at school. I feel like they're being schooled by Ripple's legal team, to be quite blunt.
I could be more blunt than that, Chris. I think they're being schooled by XRP holders at this point.
Well, there is that. Maybe they should have been schooled by the XRP holders before actually, you know, filing the lawsuit. But you know,
go the XRP army; they'll sort them out.
Everyone loves an army.
They do. They do. So, you know, the SEC could have been in disagreement about XRP's status about 2 months before they filed the lawsuit against Ripple Labs, Garlinghouse, and Larsen themselves. The argument of intent or recklessness in relation to the allegations against the two Ripple bosses would then probably be difficult for the SEC to sustain. The letter states the following: "Accordingly, if its internal documents disclose, as they undoubtedly will, that the SEC itself could not reach consensus about when a digital currency is a security and when it is not, it can hardly claim that market participants were in a superior position to know what the law requires." And that is a really good paragraph to kind of, you know, put a nail in a coffin, because it won't be the final nail. I know it's going to be many, I'm sure, but it's going to be one of the nails if you really think about it. I mean, if the SEC don't know, how on earth were Ripple to know that they were selling unregistered securities? And how were the exchanges to know that they were selling XRP as a security? And how were the retail investors supposed to know if the SEC themselves were undecided as of late of October 2020? I mean, you just can't get any more ridiculous than that.
Yeah, I was going to say, just going back to like the approach side of things, like I'm all about education, right? Like for me, there should, the SEC action should be to come up with a framework of what a security is in this space, and educate the retail investor, and educate the project leads, the teams on the projects, the exchanges, maybe even have a process that somebody, like an application that you have to go through in order to be deemed a utility token, a security token, or whatever it might be. That for me would be a better approach, right? Because it's a way of educating everybody in the space as well.
Absolutely. But Chris, we aren't finished yet. Last but not least, Hogan also points out another important aspect that could put the judge on Ripple's side. And here's the quote. Finally, the SEC is not helping itself when it tells the judge half-truths. See section 3. You can't tell the court you produced 97,000 documents when half of the documents were produced from Ripple to the SEC per litigation. That is a sure way to piss off the judge. I mean, yeah. It's definitely, I don't know if they're deliberately trying to lose. I mean, that could be one avenue. They could be deliberately trying to just throw off 2021 for XRP for whatever reason, but they're definitely not trying to win. That's pretty obvious at this point, I think.
Well, I'd be worried if they were, and potentially maybe heads need to roll if they're not actually trying to lose this case. Like, if you're trying to lose it, why don't you just get it thrown out and just come up with the clarity that's required, and let everybody move on, right? Like, you've got to do what's right by the retail investors, based on what your mission statement details. So but it's just me. Like, for me, it is a bit of a sitcom, a bit of a drama, and for me, like, it's probably a good thing. I've mentioned this before. I think it's a good thing for Ripple and XRP as they're separate entities, right?
It would have been better in 2019. I'm just going to say that.
Yeah, that definitely.
So I'm going to put my tinfoil hat on, Chris. I'm going to just pick it up. I'm just going to put it on my head here, because if they are doing this much of a bad job on trying to win a case, to me, it just feels like they're trying to lose at this point. It's just beyond a joke. Then why even do it? Is it actually just tinfoil hat here, trying to just drag this thing on during the bull market to deliberately keep XRP down and to keep US investors out of XRP? Tinfoil hat comes off, and continue as you were, Chris.
Yeah, like, possibly it is. I'm not sort of signed up to that. I kind of feel like maybe there is a more sinister reason, but I don't think it's that so much. I think maybe the previous people that work there, or one or two of the individuals, didn't see eye to eye with some of the people that work at Ripple potentially, and it was an opportunity on the way out to cause some aggro for somebody that perhaps you don't like. I mean, again, I'm surmising. I'm not saying that any of this is factual, but like, I do think it's good for XRP, and it was good for Ripple, because I think they're going to be the first. I don't think they're going to be the last. And don't get me wrong, it is a bit of a shit show, to say the least. So I don't think many of the projects in the space are going to be worrying, seeing how this all unfolds potentially. But I think it's good to be the first one, because I think the SEC are learning some lessons here. They are being schooled, and I think the next project that they may, or in my opinion, that they may go after, I don't know what project that's going to be.
I'd say Ethereum.
But it won't be Ethereum, but it'll be one of the others, and I'd expect them to have learned some lessons. Yeah, they've probably got this sheet in my imaginary, in my mind, in my imagination. They've got this sheet, and they're being schooled. They're learning all these lessons, and the next project they go after is going to be a bit more of a solid case. I kind of feel. So I think it's a good thing. I don't think they'd be the last, and that's why I'm saying I think it's a good thing that they were first. It gets it done. They get the clarity that's required, and they get to move on. I do expect the case to be settled. I think I've said this for months, Nick. I expect it to be settled. I can't see any other way. But maybe I'm wrong.
Yeah, I mean, yeah, let us know what you think. Do you think it will go all the way through, and someone will be found guilty and, all that kind of fines issued and all that jazz? Or do you think it will settle? Let us know in the comments below. Really interested to know what Bill's thinking and what your thoughts are. So, guys, if you found this useful, informative, maybe even entertaining, hit the like button. We both really do appreciate that. And of course, if you're new to the channel and you're not yet subscribed, do consider subscribing, because by subscribing, you'll be kept up to date with all of the videos and live streams that we do here at Cheeky Crypto. Well, with that said, we hope everyone has a fantastic day, and we'll catch you all in the next one.
Yeah, take care.